Hello everyone. So today we are going to start our lecture number 5 for NCA professional responsibility. So from topic some specific practice areas, we are going to cover third and fourth one. Firstly, we'll be talking about government lawyers. If you are a government lawyer, are there any bigger responsibilities than practicing as a normal individual lawyer, or both are on the same pedestal? Then we'll be talking about how lawyers have to do their professional job, professional responsibility when they are working in some company, in some law firm, in an organizational setting. So for government lawyers, we can call them public lawyers as well. So public sector lawyers work for one of the three levels of government. So we know that there are three levels of government. So for those levels of government or for any other public entity, public organization that have been created with the rise of administrative state. So we have government lawyers like for hospitals, for school boards, wherever, whichever authority is governed by some provincial or federal level of government or some local level of government administration, and they need a representation in the court of law. So for example, someone is filing a case against a hospital, so then who is going to represent hospital? So in the court of law there would be a public prosecutor, a government lawyer. So hospital, school board, public utilities, security commission, crown corporation, human right commission, legal aid clinic. Hutchinson described government lawyer as orphans of legal ethic because they say that they have little energy towards defining and defending the role and duties of government lawyer. The government lawyer works for federal, provincial or local level of government, municipal government. So this is what Hutchinson says, but it's not always the case. Everyone has their opinion and we are just here sharing the opinions of few important scholars. Model Code 7.4, the law in public office. So this is the rule that you have to mention in examination if you're getting a question on government lawyer. So this code's first rule says standard of conduct. So a lawyer who holds public office, who is a government lawyer, must, in discharge of official duty, follow the standard of conduct as high as required by a lawyer engaged in practice of law. So they say that it's okay, you are getting a proper salary, you are not concerned about fees or anything, does not matter, you have to work as an orphan of legal ethic, as Hutchinson say. You have to show your brilliance, you have to show your advocacy, you have to show your professional responsibility as high as other lawyers who engage in the practice of law. So it does not matter if you are representing a government, you are a lawyer and you have to perform equally. So the rule applies to a lawyer who is elected, appointed to a legislative administrative office because of professional qualification. Because such a lawyer is in public eye, legal profession can more readily be brought into disrepute by a failure to observe its ethical standing. This person who is representing a government is more in the public eye because everyone feels that okay, this is the public prosecutor, he must have been very qualified, because it's not very simple to get a job as a government lawyer. So legal profession can be brought into disrepute, it can be questioned, even it can question the authorities, the government who has qualified, who has appointed that person as a government lawyer, if that person does not observe the ethical standard. So you need to be very careful, you need to follow your duties as a lawyer very carefully, as high as other advocates if you are a government lawyer. So Adam Doddick has a beautiful work named Lawyering at the Intersection of Public Law and Legal Ethics. So in this he has mentioned about the Crown Council. So exercising public power is what it implies to be lawyer for Crown, because a Crown essentially personifies exercise of state power. Government lawyer translate advise advocate, as we all know that, on power of government, or we can say Crown. All government lawyers are agent of Attorney General, who is the head of all the state legal things. Under the carried on a doctrine, Attorney General can only satisfy obligation duty of office through delegation of his or her agent. As a matter of public law, this is important line. In examination, if you're getting a question simply on what do you expect from a, what are the professional responsibilities you expect from a government lawyer, then you have to mention after the model code rules these kind of things. That Adam Dodek in Lawyering and Intersection of Public Law and Legal Ethics has beautifully said that government lawyers should owe higher ethical duties than private lawyer because they exercise public power. So this is an opinion that can be incorporated to an essay. If you support this opinion, you can reference Dodek. So this is how you're going to write. This is what I just said. That if you also believe that a government lawyer should owe higher ethical duties, if you have this belief, this opinion, then you can refer his work in examination. So there is another work by Miliha Wilson with opposing argument. So if you in examination or even if in your personal viewpoint also you do not believe that government lawyers should owe more or higher ethical duty than any other lawyer and they should be at the same pedestal with the other lawyers, then you can refer this work in examination, professionalism and public interest. But keep in mind that if you have something in your notes, it's not that you are going to write in examination anything and everything. You have to pick and choose your viewpoint, your opinion, especially for this examination, which is more theoretical based. Then you have to refer that material in examination. For example, in conclusion, you are writing that okay, a government lawyer should not work, should be at the equal level as other lawyers. There should be no partiality in the professional or ethical responsibility based on whether you are a public lawyer or you are a private lawyer, and you are referring the work of Dodek, then that will give a very bad impression on the answer writing checker, because person will get to know that okay, you have just write down things from your notes and you have not followed the question. So don't do this mistake. So Maliha Wilson, professionalism and public interest. Now let's read what this person says. Fact that public law operate at intersection of three axes does not necessarily translate into higher ethical standards. So in the very first line, clear contrary view to Doddick. So if you supported this position that public lawyers should not owe higher ethical duties, you may claim you concur with Wilson's standpoint. However, more support exists for Doddick view. So this is also important to note. Imposing higher ethical standard on government law without regard to diversity of the practice, needs and duties of the ministries and agencies they serve would hinder the delivery of legal services. So this person says that it is unnecessary to add on some higher ethical standards because already they are serving few ministries and they know their duties. So this will unnecessarily interfere in their delivery of legal services. It is the public official who exercise public power, not the government lawyer who advise them. So here this person is saying that the main responsibility is on the public official who have done something right or wrong, not on the government lawyer. So you cannot put anything extra on a government lawyer. Discretionary power of government lawyer is demarcated by institutional constitutional boundaries which they work. Function and job of government lawyer is to state what the law is. Safeguard public interest. Government lawyers serve the public interest by representing their client to the best of their ability, asserting whatever arguments they can in order to achieve their client's goal. So this is simply what a normal lawyer also do. So this is what Wilson says, that only thing that we can expect from a lawyer to just serve the public interest. No need to put any extra pressure. So now the third important writing that you have to mention in examination, because Alan Hutchinson is a person who is one of the most important scholars. So he says in the public interest, the responsibility of lawyer, rights of government lawyer, that a lawyer should always have one thing back in his mind, clear in his mind, that if he or she is a government lawyer, then the obligation, ethical obligations cannot be put at hostage, cannot be ignored. The person has to follow all the professional responsibilities and ethical expectation. So now important case. So these are two cases. In the first case, the judge said that a government lawyer should work in a higher capacity, like with more ethical responsibilities, higher ethical responsibilities than a private lawyer. In furtherance to this case, an appeal was filed in 1992 in which opposite decision was given. So in that case, it was held that it does not matter whether you are a government lawyer, you are a private lawyer, as long as you are bound by a law society, you have taken an oath as a lawyer, you have equal responsibility to serve justice. So you can refer these cases in examination and you can see whichever viewpoint you believe is right and you can accordingly have that case. So Boren's justice in the first case used two rules. Rule number 10, commentary 14. When acting as an advocate, lawyer must respect the client resolutely, honorably within the limits of law. So in this case, what happened? The Crown Counsel, the lawyer who was representing the government, met patient personally when patients, the person who was the party to the case, was not having his lawyer with him. So he met in private capacity, the client. So conduct represented a violation of rules and commentary by the lawyer for the Crown, Mr. Wickett. So just because Crown Counsel met the client in person, opposing party, privately, judge in this case said that this is not what we expect from a Crown Counsel. So Mr. Wickett should not be permitted to continue as solicitor as counsel as his conduct constituted serious indiscretion. So Lepage is seriously impacted by the conduct. His confidence in the system, the client whom he met personally, is damaged, undermined. I must disqualify Mr. Wickett from any further participation in this litigation. So these were two important things that were stated in the reasoning by judge. When a lawyer is employed by government, they must particularly sensitive to the rules which govern his or her professional conduct. So here, see the line. They should be held to higher obligation than lawyers generally. Government law represent reflect the public interest. There exists a special unique responsibility, duty on government lawyer to be particularly sensitive to rules of professional conduct. Now let's look into second important case, appeal. So in furtherance to previous disqualification of Crown Counsel to further involvement in a lawsuit against Ontario government, Attorney General filed an appeal. So there were two issues. First, whether a solicitor who is acting against a patient be disqualified from continuing because he met privately with the patient in the institution without patient's own counsel. Secondly, whether a reasonably fair-minded person would conclude that such one incident requires removal of solicitor from further involvement in case. So here what happened in appeal, the court said in previous case the judge failed, erred in law by concluding that solicitor has breached the rule and commentary. There is no premise for the motion court judge to conclude the rule was breached. No lawyer can entirely avoid all contact. There is no ground or premise for misunderstanding that government lawyers have a higher professional obligation than other lawyers. So this thing is wrong. And the court said all lawyers in Ontario are subject to same single high standard of professional conduct. In respect of the liability under rules of professional conduct, Crown Counsel stand on exactly the same footing as every member of bar. So this is very, very important. 100% you have to mention this in examination. The court refused the reasoning of Judge Boris, the previous case, the motion judge, that government lawyers have higher obligation. So unique duties of Crown Counsel in conduct of public prosecution are well known. Courts have come to anticipate a specific degree of conduct and expertise from Crown Counsel. However, if you are expecting something does not mean, then this requires a higher standard of liability than any other lawyer. So here we're talking about liability. Public interest in administration of justice require an unqualified perception of its fairness in eyes of general public. A lawyer has to be fair, has to perform his or her duty, expertise in a particular manner. as per best of their ability, it does not mean that they have liability, more liability than any other lawyer. So that was all about government lawyer. Now talking about lawyers in organizational setting. So word organization means law firm lawyers who are acting in any kind of firm. Lawyers working as corporate counsel, in-house counsel, which we say, build and foster relation with clients that may not squarely with traditional model of sole practitioner or lawyer in a law firm representing individuals. That is in-house, do not give advice and walk away. So what happens? So the concept of in-house counsel is not like you are just giving an advice and walking away. Today, lawyers who are working as corporate counsels have many more other responsibilities. Firstly, they have to face the challenge of sustaining independence, impartiality, integrity as professionals. Side by side, they also have to perform their function as employees of a particular company on behalf of which they are advising. So they have dual role to perform, dual responsibilities. So Cheryl Forey, important scholar, has said the advice from in-house counsel can't be given in a memo with disclaimer without regard for the business reality or the personal consequences. So lawyers are lawyers first and business second. As such, lawyers do not have a choice when it comes to ethics and values. The assessment of professional responsibility and ethics inherent in each decision a lawyer makes is not a consideration for average business purpose. So this thing has to be balanced. So today, the lawyers who work in organizational settings usually keep both these things side, like they act as a lawyer and they keep this business thing aside because the role that they perform for the business purpose in a law firm, that is as an employee of that company, but otherwise the independence, the kind of professional responsibility that they owe, that they have as a lawyer. So John Maxwell has said that there is no such thing as business ethics. There's only one rule for making decision. There are no rules of ethics in business. But no matter whosoever, whatsoever says, these lawyers do have their loyalty. So the loyalty that we read the concept in the beginning of this course, so they do owe their loyalty. So the client is the organization itself. So if a client is coming to a particular law firm and the law firm is assigning a lawyer, then that lawyer has a responsibility to give their best to their company because the client is coming to their company, and in a way a particular lawyer is working as an agent between the company and client. So this is important to note that the lawyers do owe responsibility of being loyal. So Model Code Rule 3.23 says when the client is an organization. So here in a law firm, you have to keep this thing in mind that here your client is your organization on behalf of whom you are working. So although lawyer may receive instruction from an officer, employee, agent, when a lawyer is employed, retained by an organization, including corporation, lawyer must act for the organization in exercising his or her duty in providing professional services. So this is very, very important. So this is what concludes all my previous explanation. So a lawyer acting for an organization should keep in mind that the organization, like client, corporate client, has legal personality distinct from shareholder, officer, director, employee, while organization or corporation acts and give instruction through officer, director, like the senior lawyers. Lawyers should ensure that it is the interest of organization they are served and protecting. So this is important. This is what I just told you. So what are the ethical obligations of a corporate counsel? Like we discussed in a previous topic, the ethical obligation of a government lawyer. Here, Milton C. Regan has beautifully summed up ethical obligation of corporate lawyer. So in examination, if you get a question on this topic, firstly you have to give a brief meaning of what do you understand by corporate counsel. Then They are not always for the business. A lawyer is a lawyer no matter if he or she is a corporate counsel. Then write the Model Code Rule 3.23, then go by the 11th rule of commentary, then further add on these kind of works or case law. So gradually there has been growing reliance on in-house legal department counsels. Corporations now tend to seek specialized knowledge, expertise rather than general service from outside counsel. So they have their own. A company has their own in-house legal departments, in-house counsel rather than just asking for any random outside counsel to give them advice. So employers who represent a corporation are in fact representing an abstraction. Company act and give instruction through its officer, director and employee. Many corporate lawyers do not just represent organizations but are employed by them. So they don't directly sometimes represent, but they are employed as a worker, employee. In-house counsel is in unique position to provide combination of business legal advice that help organizations strategize for a tumultuous global economy. With the increasingly global nature of legal practice, national boundaries pose no obstacle to modern corporate activity. There is no collective set of ethical provisions that are applicable to lawyers engaged in cross-border practice. So market-based economy assigns to corporations significant power over matter of extensive social importance. This requires corporate law to play two roles, that to some degree are in tension, both private and public dimension, business versus lawyering. So these are the two roles that the corporate lawyer have to perform, and they have to do justice with both these roles. So again, Christopher Whelan in Privatizing Professionalism, Client Control of Lawyers Ethic has talked about corporate clients. Corporate client and in particular global corporation gaining influence control over lawyers' practices as a scope significantly above and beyond which had been customary in past. So in past, we always saw and we always read that lawyer and business, these things are different. But in today's world, when everything is getting privatized, when we are globalizing, expanding, so this thing, corporate clients, have become a part and parcel of our legal world. So in particular, norms relating to both lawyers' practice and lawyers' ethics that had formerly been under the domain of professional state bodies, now how a lawyer work, how a lawyer perform, this has been controlled for the corporate lawyers by their own firms. Like they have to follow a particular law firm's procedure, guideline, code of conduct, manual, best practices memorandum, which lawyers are expected to follow. So these law firms have their own rules and regulations, like professional rules and regulations that their hired corporate counsels have to perform. So this is how we are saying that this profession is somewhat becoming privatized. So there are few additional writings in notes if you want to follow, but in examination you can write these two, three as well. That would be more than enough for this topic. And then you can add this case. So Wilder versus Ontario Security Commission 2001 case. So firstly, let's read the fact. Appeal called into question the authority of Ontario Security Commission to reprimand Lawrence D. Wilder, lawyer appellant, for alleged misconduct in relation to his representation of client before this commission, Ontario Securities Commission. Law Society claims that OSC does not obtain statutory mandate or authority to reprimand Wilder for his conduct. Law Society contends that allegations made against him must be handled via quasi-criminal proceeding or by Law Society. So issue was, does the OSC have jurisdiction as a matter of statutory interpretation to reprimand Wilder for alleged misconduct? Does OSC have jurisdiction to reprimand lawyers for their conduct as solicitor before Ontario Security Commission? So analysis, does the OSC have jurisdiction as a matter of statutory interpretation to reprimand? So court held that OSC has requisite jurisdiction as a matter of ordinary statutory construction interpretation. OSC is charged with statutory obligation to do its best to ensure that those involved in this industry provide fair and accurate information so that public confidence on the integrity of capital market is maintained. It is difficult to imagine anything that could be more important to protecting integrity than ensuring that those involved, whether as direct participant or as advisor, lawyer, full and accurate information to OSC. So OSC is expected that the people who are advising the commission for legal things are providing right information, and if as per OSC rules and regulation those people are not giving proper legal advice, then OSC is allowed to walk into the matter and take appropriate action. So they stated that arguments made by appellant had nothing to do with Wilder's status as a solicitor member of law society. They are based entirely upon the wording of relevant provision of Act would apply to any person corporation alleged to have provided misleading untrue information to OSC. There is nothing in the language or text of section 127 nor in its legislative history and background to suggest and insinuate it should not be applicable to lawyers. So the rules of OSC does not say that they cannot take action if someone is providing any misleading untrue information to them. So and it also applies to any person, any corporation who is providing untrue information. So that does not mean that lawyers are excluded. If lawyers are working for a particular corporation and that corporation has a rule, as an employee of that corporation, those rules do apply to lawyer. So paramount object of Security Act to ensure that person who in the province carry on business of trading in security acting in investment council shall be honest, of good repute, in this way to protect the public. So this is important. Here in this case, the investment councils, the lawyers, they missed on this particular important rule of OSC. So OSC must ensure the substantive legal right to solicitor-client privilege is respected. I do not accept the contention of the appellant and the law society that the need to respect solicitor-client privilege require a blanket precaution, preventing the OSC from reprimanding lawyer in all cases, providing OSC pays adequate heed to importance of solicitor-client privilege. So what was concluded? So Enron scandal and reactions by legislators and regulators in US set the stage for central changes. So Canadian lawyers are not immune for inquiry discipline by regulator other than their own law society. So they can be questioned by their particular organization for which they are working as corporate counsel. So in Canada also this is the same rule. So knowing the general rules concerning the client relationship, privilege, confidentiality, and the difference between legal business advice is critical for lawyer and organization setting. This line you have to mention in the examination. Just paraphrase it and mention this is very important line. This concludes this whole concept of a crown counsel that okay, you have to respect everything, all the things that are required by professional model conducts, but difference between legal and business advice is critical. Lawyers should know in an organizational setting and respect this thing. So that was all about today. Thank you and good luck.